Hi friends, welcome to BooK channel. Hey there viewer. Do you like US-ANG arbitration? Today we will learn about arbitration advantages and disadvantages of arbitration. In today's video, we will be talking about arbitration, you should be US-ANG arbitration and more. Stay tuned until the end. Without wasting any time, let's get started. Arbitration is a method of dispute resolution where parties involved in a legal conflict agree to submit their case to an impartial third party, known as an arbitrator or arbitration panel. The arbitrator's decision, called an award, is legally binding on the parties involved. Here are some of the advantages and disadvantages of arbitration. Advantages of arbitration. Speedy resolution. Arbitration can provide a quicker resolution compared to court litigation. Cost-effective. It can be less expensive than traditional court proceedings, especially for complex cases. Expertise of arbitrators. Arbitrators are often professionals with specialized knowledge in the relevant field. Confidentiality. Arbitration proceedings are typically private, preserving the parties' confidentiality. Flexibility. The parties have more control over the arbitration process and can agree on specific rules. Finality. The arbitrator's decision is usually binding and final, providing closure to the dispute. International disputes. Arbitration is commonly used for resolving cross-border disputes due to its enforceability in multiple jurisdictions. Informality. The process is generally less formal than court proceedings, making it more accessible. Neutrality. Arbitrators are neutral third parties, reducing potential bias or favoritism. Less adversarial. Arbitration can foster a more cooperative and collaborative approach to resolving conflicts. Disadvantages of arbitration. Limited appeal. The grounds for challenging an arbitration award are more restricted than those for appealing a court decision. Cost allocation. The cost of arbitration may be unevenly distributed, disadvantaging one party. Lack of precedent. Arbitration decisions do not set legal precedents as court decisions do. Limited discovery. The scope of evidence gathering may be narrower in arbitration. Non-judicial enforcement. Enforcing arbitration awards may be more complicated and time-consuming. Mandatory arbitration clauses. Some agreements may include mandatory arbitration clauses, limiting individuals' rights to pursue court litigation. Lack of public records. Arbitration outcomes are generally not accessible to the public, potentially affecting transparency. Limited remedies. Arbitrators may have fewer remedies available compared to those in a court setting. No jury. There is no option for a jury trial in arbitration, which some parties may prefer. Unequal bargaining power. In some cases, one party may have significantly more bargaining power, leading to potential unfairness. Conclusion. Arbitration offers several benefits, such as speed, cost-effectiveness, expertise, and confidentiality. It is an effective alternative to traditional court litigation, particularly in complex or international disputes. However, arbitration is not without its drawbacks, including limited appeal rights, potential cost disparities, and concerns about transparency. Parties considering arbitration should carefully weigh the pros and cons to determine if it aligns with their specific needs and preferences. In many cases, choosing arbitration can lead to a fair and efficient resolution, but it's essential to ensure that the arbitration agreement is well drafted and that all parties understand its implications before proceeding.